A very good afternoon, everyone. I hope you can hear me. Welcome to the Avid Readers Forum. My name is Marion Joy, and I will be moderating this session. We will start with a word of prayer from Sylvia Nyaberi. Sylvia, welcome.
Let us pray. Gracious and merciful Father in heaven, we are thankful for this day. Thank you for the chance you have granted us. We do pray for your presence and your blessings, that even as we have this discussion, may you fill us with your wisdom. May you bless all the participants and the panelists, and may you be with us till the end. It is my humble prayer in Jesus' name. Amen.
Amen, amen. Thank you for that wonderful prayer, Sylvia. I'd like to once again welcome all of you to the Avid Readers Forum. Before we start, seeing that we're in the legal profession and it's a very sad week for the legal profession, we would like to take a moment of silence to mourn the loss of Justice Monica Kituvi, who was murdered last week. So we'll just take a minute of silence to just celebrate her life. Thank you, everyone. May her soul rest in eternal peace. Now, I would like to introduce you to the Avid Readers Forum for those who are attending it for the very first time. The forum is a forum run by the Kabarak Law School. It's a platform for reading and having discourse on various legal issues happening in Kenya and beyond. It was initiated in 2019 by the very great Mr. Elisha Ongoya, with the aim of fostering acquisition of knowledge and intellectual engagements among students. Over time, it has grown to be a platform for discourse on topical legal issues within the academy and in the wider legal fraternity. This particular forum was a collaboration with Ms Wanjiru Gikonyo, who is the founder of the Institute for Social Accountability. We hope to have a series of webinars to discuss political and fiscal accountability in Kenya. And each of those webinars will touch on different but related areas that are part of past and ongoing public interest litigation cases. This particular webinar will discuss accountability in public finance in Kenya with a focus on the Constituency Development Fund case. The full citation would be Institute for Social Accountability and another versus National Assembly and another, Petition 1 of 2018. I hope you all had a chance to look at that case. And so we have 4 panelists today. We have, first of all, Mr. Wachira Maina. Mr. Wachira Maina is a constitutional law lawyer, public finance expert, and he has experience advising governments and organizations on matters government. And most recently, and we are honored that he's a senior lecturer at Kabarak Law School. We also have Mr. Elisha Ongoya, who is an advocate of the High Court of Kenya, a governance law expert, and a senior lecturer at Kabarak University Law School. We also have Mr. Ochiel Dudley, who is an advocate of the High Court of Kenya and a seasoned public interest litigant. Mr. Dudley is also the recipient of the Jurist of the Year Award for 2023, given by the International Commission of Jurists, Kenya chapter. And lastly, we have Ms. Wanjiru Gikonyo, who is an advocate for good governance. She is also a civil society actor with many years of experience in advocating for social and political accountability. Ms. Gikonyo is also the founder of the Institute for Social Accountability. These are our panelists for this session, and we're very, very honored that they found the time to join us today. So we will get straight into it. We will have the initial thoughts by the panelists, and then later we'll have the plenary session where you, members of the audience, will have a chance to make comments, ask questions, and engage on the topic of discussion today. Thereafter, we'll have concluding statements, closing remarks, and the closing prayer. So now I would like to move into the part where we hear from our panelists. And I'll start by inviting Ms. Wanjiru Gikonyo. Ms. Wanjiru Gikonyo will talk about the motivations behind the case. We note that she / Tisa was a petitioner in this case. So we'll invite her to tell us more about that case. Ms. Wanjiru Gikonyo, feel much welcome.
Thank you very much, Marion and colleagues, and thank you for this opportunity. We got involved with the CDF case actually through Mr. Ongoya, and Elisha will be sharing that side, the legal side of things. For ourselves, as the Institute for Social Accountability then, we were looking at the issue of local governance. Because local governance is supposed to give voice to citizens. So we were looking at citizen-centered development and had identified that effective decentralization was an effective way to do this. And when we looked at the history of Kenya, we found that from the point of independence, there had been a struggle, which we are aware of, a struggle with the Majimbo provisions in the Independence Constitution, a struggle with something that was called Special Areas Development in the 70s, a struggle with the local authorities, a struggle with the district focus for rural development. So this struggle was about moving power from the center to the local level. Because when you talk about devolution properly, you're saying that administrative decision-making and capacity, you're talking about financial decision-making, you're talking about political decision-making, all being moved to the local level as a way of democratizing development and getting out of the hegemony and the authoritarian, centralist state. Of course, in development terms, supposed to be more responsive, supposed to enjoy it is at the from their own the CDF was going to interfere with that come up in the dialogue around through the constitution that had been enacted. And we saw that this competition between the CDF and devolution would put devolution at a disadvantage, because Parliament will then be looking at their own interests rather than looking at the interests of the devolved government. I've just seen a message. I hope my line is clear, Marion.
You seem to be breaking.
You're breaking, Wanjiru.
Sorry, let me just check on my connection. I apologize.
You seem to be breaking, so perhaps.
She's not breaking anything.
Oh, okay. We seem to have lost Ms. Wanjiru there, but not to worry, not to worry. She will join. I'm pretty sure she'll be able to join. Or she's already joining back. Welcome, Ms. Wanjiru.
Apologies.
And we can't hear you. Can we? Welcome, welcome.
Is that, can you hear me now?
Can you hear us?
I can hear you now. Allow me to move to my phone.
Sure, I can hear you from my end now clearly. You can proceed.
You can proceed, yeah.
Okay. Thank you very much. And so we then recognized that devolution was important for the country, and CDF was conflicting with devolution, and we then articulated some of the arguments that will be brought out. And we've had a series of cases from the High Court to the Court of Appeal all the way to the Supreme Court. Now, some of the developmental issues that were driving us, because I won't speak to the legal, it's really to say we make legal arguments so that they can assist the development. What were we seeing on the ground? We were seeing that fiscal decentralization, these funds needed to link to national goals. And we were seeing there was a disconnect because at the time the CDF was set up, there were numerous other funds. And KIPRA and others had done studies on these funds. And we had found they have common challenges. They were not linking properly to national goals, which means they were a bit politically motivated. They were not coordinating with each other properly. So you had funds that were parallel. They had, of course, then a lot of overlap and duplication, including what you call double funding. CDF would do a project, the local authority fund says it's theirs. We also had, the framework for managing them, the administration, the monitoring, the evaluation, the financial management were all separate. So at the time, I think there were over 10 funds, all with their own administrative structure. And we were saying, this is extremely wasteful. And this situation pertains till today. And the number of funds at some point reduced and then now has ballooned again. So when we are talking about the cost of running government, really, there's a lot of waste in this duplication. We also saw that citizen engagement across these funds was weak and tokenistic, especially at the implementation and oversight level. And we saw a lot of political interference in how projects are directed. Most importantly, we weren't getting a good sense of how these funds were going to affect, going to meet the need for inclusion, the need for equity, and the need for sustainability because of their political nature. And given that, we then did our legal review, worked with our lawyers, and formulated the issues that we brought to court. So when we think about where we are now in this CDF conversation, and as we see Parliament proposing to entrench the CDF in the Constitution, alongside the legal arguments, the very real legal arguments around separation of powers and such, there's also these development questions that need to be asked. As we sit today, we have pollution really of devolution structure. Don't have that are ready.
Ms. Gikonyo, you seem to be breaking again. Did we lose you now? Okay, we will give Ms. Gikonyo a moment to fix her internet issues. I believe there will be internet or device issues. Meanwhile, A warm welcome to everyone who has joined us in this session. We are very happy that you are here. Remember, you can type your comments and questions in the chat box. We are here to discuss the financial accountability in Kenya with a focus on the Constituency Development Fund case that was decided by the Supreme Court. And now, Ms. Gikonyo, can you hear us?
I'm trying to connect. Are you able to hear me?
Yes, we can hear you now.
Okay, I apologize. I usually have very stable network. It would wait for an important event to then begin acting up. I'm not sure at which point you lost me. So I'm not sure how far back to go.
Ms. Gikonyo, you had taken us through the multiple funds, this multiplicity of funds, and how they were causing more confusion than order, and how they were politically established. I think we lost Ms. Gikonyo completely now. She dropped.
It's okay. No, not to worry. We can move to Mr. Ochiel Dudley, and then Ms. Gikonyo can perhaps complete her thoughts later. You're muted. Yes, Ms. Gikonyo.
I'm hoping now I'll be able to move without interruption. Where do I'm not sure where I left off, how far back I should go. Marion, could you guide me?
You were talking about multiple funds.
Right. Okay, so I may repeat a bit, and if that's the case, I'll just ask that you bear with me. I'll try and be fast. So part of the motivation for the fund was because we were very keen on supporting citizen-centered development around the principles of administrative, financial, and political decentralization. And at the time, there were numerous funds. So we had a national centralized government that was then running numerous funds. And all these funds had the same challenges. In other words, we had fiscal decentralization that was actually centralized and very ineffective. So it wasn't linked to national goals. It wasn't well coordinated. These funds were overlapping, duplicating, and wasteful. They weren't harmonized in terms of the regulatory framework for planning, for monitoring, for evaluation. They had a lot of political interference. And so that actually funds were being created politically. And this is taxpayers' money. And at this point, when we are talking about having the fiscal crunch that we do, we really need to be alive to what we are saying when we have multiple legal and that even some are regulatory and administrative financial structures, this duplication. And we also saw very unhealthy competition. Instead of having complementarity in development, we were seeing unhealthy competition between MPs, between, at that point, it was councillors. So with the coming of devolution, we had a report which we submitted to Parliament. We had conversations with the committee responsible for CDF. They undertook to align the CDF to the Constitution. And aligning it, in our mind, meant it needed to move away from the constituency level, it needed to move away from the MP, it needed to move into the devolved framework. But of course, we saw that once the legislative process started, Parliament began tinkering with the law and ensured they tweaked it a little bit so that it looked okay. But when we got into the detail, we realized they didn't do much. They wanted to retain control of what we consider to be a slush fund, a political fund, a fund to advance their political ends. And so we went to court. And so as we sit now, because we'll hear the legal
We seem to have lost Ms. Gikonyo again.
efficiencies. What is the accountability? What is the impact of the fund and the sustainability? And how effective is it in terms of equity? We are not able to do that when we over-politicize a fund. We are not able to do that when we are not properly reporting. We've seen in subsequent amendments of the law, the reporting and transparency of the fund has increased, but the accountability has reduced. When we started out, it was very easy to get a list of the specific CDF funds. Now it's not. Now we deal with the universal, with the global figure that goes to the constituency. And this list has become very difficult to get. So that means accountability is reduced. The reporting, there was a requirement for an evaluation report to be done regularly. This was then removed so that Parliament now just has to meet an audit reporting requirement. And audit reporting can be really, it's just saying this amount of money went in, this amount of money was accounted for without getting into the evaluation details. That said, and my last point is, the last detailed report that Parliament did on the CDF, they found about a 50% completion rate. And this, I believe, this report was probably, I was looking for it before, I couldn't find it. I think 2018, 2019. So they found they are really struggling with completion rates, which really is about saying, yes, we have a fund. It's very popular with the people. It gives very good opportunities. So there are good lessons to learn in terms of local procurement opportunities. And in fact, the CDF has informed the AGPO, which is the preferential procurement opportunity, because we need to decentralize opportunities. But those opportunities need to then feed into sustainable use of funds so that we ensure the projects are completed, not initiated politically, where the next MP comes and decides he's not going to work on the previous projects because they are not of interest. I'll stop there. Thank you for your time and look forward to the rest of the discussion.
Thank you very much, Ms. Gikonyo. And I have to report that Mr. Wachira Maina, who's here with me, was clapping for you. So just receive the claps. I can see some more claps in the Zoom call. So thank you very much for that erudite presentation. Now we know the motivations behind this case. Thank you very much for setting that context for us. And now we'd like to know the legal underpinnings behind the case, the legal background, the legal analysis of the case. And to that, I will invite Mr. Ochiel Dudley, who, as some of us have interacted with his thoughts, and we know he's a very erudite speaker also. So much welcome, Mr. Ochiel Dudley.
Thank you for having me. I met this case at the Supreme Court. It was just being drafted for the Supreme Court. It had gone to the High Court, where the High Court had nullified the fund. But then when it went to the Court of Appeal, the Court of Appeal said things like, since there was no dispute between the levels of government, the petitioners had invented a hypothetical case. Then the Court of Appeal also said things like, since this was an intergovernmental dispute. Remember, the Court of Appeal first says there's no dispute between the levels of government, so the petitioners had invented a case. But then the Court of Appeal also says that since this is an intergovernmental dispute, we should have exhausted intergovernmental dispute resolution fora under the Intergovernmental Relations Act. And I found the case when it was just being prepared for the Supreme Court, and some of the arguments that were made was whether the Court of Appeal was right in saying that a citizen like TISA is an agency of government that has access to the Intergovernmental Disputes Resolution Forum. And also whether the Court of Appeal was right in saying that if the levels of government are not disputing, they in concert, for example, to oppress the citizens, then the citizens have no dispute. In other words, whether the question whether an act is unconstitutional was an hypothetical dispute created by the petitioners. Remember, the petitioners disputed the validity of that act, and then there were more substantive arguments. The question whether the act had been impliedly repealed. The doctrine of implied repeal goes to the extent that where Parliament enacts two competing laws and that cannot stand side by side, then the earlier law is deemed repeal because Parliament is aware of it. In this case, the High Court had given a 12-month suspension for Parliament to amend the law to bring it into conformity with the judgment. And on the last day for that 1-year suspension of invalidity, suspension of invalidity is another remedy that the courts can give. The court declares the statute unconstitutional, and then it allows Parliament time to correct the unconstitutionality. And it does that because sometimes contractors have been appointed, you have kids on bursary, you have budgets already out there. So if you say that the law ends and it ends today, then it can lead to some anarchy in governance. So the High Court gave Parliament 12 months to correct the issues it had found in the judgment. And on the last day of that suspension, Parliament enacted the National Government Constituency Development Fund Act of 2015, 15 or 16, sorry. So we asked the Supreme Court to tell us whether that new act had repealed the earlier act so that the dispute was now moot. Because when there's a change in the law, when the facts have changed so that the dispute is no longer what it was at the time when the court is giving judgment, then a case is said to be moot. We lost on that limb, but I'm now happy that we lost. I'm happy we lost because the Supreme Court found that the matter was not moot. It was able to give us, I think, the most comprehensive and easy to read, yet most authoritative decision that I've ever read from the Supreme Court of Kenya. It makes sense internally. One part is connected to the other. It's just a good judgment to read, and the timing was also quite superb. The Supreme Court delivered it on the last day to the elections so that the MPs had no time to interfere with it or to say that, so that the MPs knew when they're coming in, that they're coming in without the mandate of the CDF. The timing was perfect, the decision is perfect, the issues are quite clear, and it's a judgment that speaks to many other issues, and I think it's the strongest statement by the Supreme Court of Kenya on devolution. There have been a number of advisories on devolution, but I think that the Supreme Court CDF judgment is the most authoritative. There are issues to do with whether the CDF creates a third tier of government by having the national government and then you have the county government. And then somewhere in between those two, you have the constituency, and whether the constituency is a unit of political representation or can be a level for the performance of government functions. Maybe I could stop there and wait for another opportunity to contribute more.
Thank you very much, Mr. Ochiel Dudley. I'd like to once again report that Mr. Wachira Maina, who's here with me, just clapped for you very loudly. Thank you very much for setting the context for the case. You have noted that this judgment was just a good judgment, and we are happy to have had you present that. Thank you very much. I'd now like to invite Mr. Elisha Ongoya, who will also tell us more about the legal aspects of the case. Mr. Elisha Ongoya, much welcome.
Thank you. Thank you. I think as a litigation lawyer, I always begin by reminding people that litigation is partly a science, but significantly an art. And therefore, unlike academic writing that is largely scientific, litigation is largely artistic. There's a bit of drama in it. There's a bit of craft in it. And litigation lawyers and litigators generally don't regard themselves like academics. In fact, they use the word academic very contemptuously. They keep reminding each other, no, we are not, this is not an academic forum. We are not in an academic exercise. So they use the word academic fairly contemptuously. It's because they perceive themselves as men and women trained specifically to fashion practical problems and offer practical solutions. The easy example I keep giving people is this. If you came to my chamber here at Ongoya and Wambola Advocates and told me the bank is just about to auction your property, what you want is an order stopping the sale of your property, not the length of the judgment. You want an order. If it came in a half a sentence, stopping the sale of your property, you go away satisfied. If I got a 30-page judgment, not stopping the sale of your property, but modifying the principles in Giela versus Cashman Brown, it does not satisfy you. I can't tell you that, we lost the order, but, we have contributed to jurisprudence because Giela versus Cashman Brown is no longer the authority. Now the authority is Marion Joy versus Kenya Commercial Bank. That can make you happy. What you litigators come to court with practical problems and they want practical solutions. They are the classical businessmen. They look at the bottom line, profit or loss. If it's profit, management must go home. If it's a loss, management must go home. If it's a profit, these are good management. So they look at the bottom line. When this matter came to my desk, and Wanjiru Gikonyo here is the one who brought it to my desk, first, I was the least likely candidate to act as a lawyer in this matter, because the only reason why Wanjiru Gikonyo knew about me was because while serving as a pupil at Mohammed Muigai Advocates, I had done some article critiquing the CDF Act of 2003. An article done by a pupil. The reasoning is normally shallow and there isn't much conceptual underpinning. And she found it on the kenyalaw.org blog. And I got a call while doing my usual business in the villages. So I had to come back to Nairobi to take instructions. The practical problem then was not the CDF Act as a whole. The practical problem was that this was 2013. Members of parliament were about to go home and campaign in the 4th March 2013 elections. And they were fast-tracking release of the final tranche of CDF money so as to use them for campaigns. It's important to understand that was the problem then. Members of parliament wanted to release the final tranche of CDF money so as to use them for campaigns. A clear election corruption issue. One may look at it as an election campaign financing regulation issue. So we went to court and got a conservatory order from Justice Mumbe Ngoge stopping the release of that tranche of the money. And therefore, the practical problem had gone away. That gave room for a review of the case and a restructuring of the case. But a number of things had happened. Just by way of recap, the CDF Act had been enacted in the year 2003. It had been amended in 2007. It had been reenacted in 2013. It had been reenacted in 2013. And there was a further amendment to it in that year, 2013. Same time when the CDF Act was being reenacted to a new law, now of 2013. And the petition as filed had to be reconceptualized to now challenge this law as reenacted. Once that petition was reconceptualized, the CDF Act was amended again in 2013 through a CDF Amendment Act 2013. So you have the CDF Act 2013, then you have the CDF Amendment Act 2013. So once again, the petition had to be re-amended to accommodate the new amendments to the CDF Act. So that dynamic is important for anyone who wants to understand why there were very many amendments of this law. In the course of repackaging the petition now, remember we have stopped the release of the disbursement, and chances are there was not going to be any disbursement until after the elections of 2013, meaning the earliest the disbursement could have been done is after the elections. The original problem had gone away, and the new problem was then now to relook at the act as a whole and see the interplay between this act and devolved governance, the kind of stuff that Ms Wanjiru Gikonyo has taken us through now. And a number of issues emerged out of this, following one of which, the most basic one, was the National Assembly had enacted the CDF Act without involvement of the Senate. Very basic thing in devolved governance in this country. And of course, other issues emerged as to the nexus between the CDF as a fund and the principle of separation of powers generally. So these were the matters that went before the High Court judges, and the High Court judges allowed the petition. When they allowed the petition, of course, an appeal was filed against it to the Court of Appeal. And it is the appeal that was filed that led to literally sacrilegious jurisprudence that the Court of Appeal came up with by finding fundamentally nothing wrong with the CDF Act. It struck down one section 24 there, but the rest of it found the act to be intact. So this is what necessitated a further appeal now to the Supreme Court, culminating into the judgment that we have today. If you look at that judgment in detail, and I hope we're going to get sufficient time to do that, you'll find that the Supreme Court has essentially found the CDF and any other fund in the nature of the CDF fund unconstitutional. That's what this finding is. But members of parliament being who they are, they had enacted the CDF Act 2015, and therefore they technically continue to argue on the presumption of constitutionality. That since what was found to be offensive was the 2013 law, the 2015 law remains, according to them, valid until formally declared invalid by a court of law. Reading the Supreme Court judgment of the CDF Act 2013, it is just a matter of time before the 2015 Act is also declared unconstitutional. But I don't say much about that because I may be cited somewhere for contempt. So let me rest at that, and I'll come back when another opportunity presents itself.
Thank you very much. We wish you didn't rest at that. We wish you told us more. And I bet not many people will cite you as being in contempt of court. Thank you very much for that savvy and well-informed analysis of the case. Thank you very much. That presentation was first class. Now, I'd like to remind everyone that you can type in your chat, your comments, your questions in the chat box. And to the joy of those who have any questions and comments, your time is now. I'd now like to open the floor for... Sorry. sorry. My profuse apologies. I'd now like to invite the one and only, the great Mr. Wachira Maina to tell us more about the Constitution Development Fund. Thank you. My apologies. Welcome.
Thank you. It seems that sitting next to her is a problem because the likelihood of being forgotten is very high. Now, I want to do something different. I don't want to talk about the case. I wanted to ask the question, what is at stake in the arguments about CDF by whatever name baptized? And what I'm calling my 5 or 6 slides is the conceptual foundation of the real problem. And I intend to deal with 2 issues. The first issue is separation of powers. The second issue is something I describe as fiscal constitutionalism. Now, I want to begin by talking a little bit about by making the argument that the foundations of separation of powers and fiscal constitutionalism are actually the same. So unlike my friend Ongoya, who doesn't want to do the academic thing, I want to do the academic thing. I tell my students that it is important to go back to first principles, because the part of the problem we have with this case is our failure to go back to first principles. So for those who are not lawyers who are listening in, fiscal constitutionalism and separation of powers are based on the same 3 ideas, or the same 3 principles. The first principle is public good is the end of government. This is a very old idea. It goes back to Aristotle and the idea of the good life. And then there is the consent of the governed, the second principle. The consent of the governed is the means for achieving that public good. So that you've got public good is the end of government. The consent of the governed is the means for achieving that public good. And then the third principle is the sovereignty of the people is both the foundation of the definition of the public good, and it is the basis for the consent of the governed. So those are the 3 principles on which all legitimate constitutional government should be based on. Now, the central insight of constitutionalism is the idea that unchecked or absolute power is the same, whether it's the unchecked power of a majority, the unchecked power of an assembly, whether it's parliament or senate, or whether it's the National Assembly or Senate, the unchecked power of an aristocracy, the unchecked power of an oligarchy, and the unchecked power of a king. They all end up at the same place. And that place is called tyranny and the loss of the liberty for the citizen. So let's then begin by looking at separation of powers issues. And we want to go back to first principles on this question. So as I said, I'm not going to talk about the case, just talking about constitutional principles. Now, the reason why we separate and fragment powers is because we pursue 2 potentially contradictory objectives. One objective is to enable, to disable government, from any attempt to fuse governmental authority in one person or institution. But the second reason is actually to enable government. It is to enable government, or rather to incentivize government, to pursue the public good and to discourage the pursuit of personal interest of individual officials. So the Constitution has got this tension in the middle of it, which is it wants to disable attempts to fuse authority. At the same time, it wants to incentivize people to pursue the public good and to limit the pursuit of the interest of the self-interest of particular individuals. Now, we understand the 3 arms of government, parliament, legislature, judiciary, executive. The idea is that each institution should have, because separation of powers is not the same thing as checks and balances. And I think this is where we get lost, because the separation, you can have separated powers without having checks and balances. So, but in a constitutional system, we want the separated powers to also check and balance each other. So what we do in separation of powers in a constitutional democracy is to give each organ the institutional means and the personal incentives to check the others. And this is very well developed in the Federalist Paper number 51, for those who are interested in reading this stuff, by James Madison. And he summarizes it this way, that it consists of the necessary constitutional means and the personal motives to resist encroachment by the others. And I want to underline those 2 issues, the means and the personal motives, because that's what is going to be at stake in this CDF case. Now, when we come to the CDF issue in Kenya, what is the core problem? The core problem is that Parliament lacks both the institutional and the personal incentives, even though it has the institutional means. It lacks the institutional incentives and the personal incentives to check the executive. And I want to give you some historical background to this. Before 1998, Parliament basically operated a little bit like a department of the Office of the President, because the clerk to Parliament was actually an employee of the Office of the President. And in fact, the last clerk to Parliament was a special branch officer. So, so Parliament was controlled effectively from the Office of the President. I was involved in an effort to try and hive off Parliament from that control, and we amended the Constitution. Myself, working closely with Olo Aringo and a bunch of MPs, we actually formulated a constitutional amendment that freed the executive, the Parliament from the executive. Then one of the early orders of business was to ramp up its salary, because now it had control of its own agenda. It increased its salaries. Now, but they discovered that the salaries weren't enough to satisfy their own needs and also to satisfy the needs of their constituents. So the next amendment was CDF of 2003 to provide themselves with money. And this is part of the reason why Parliament lacks the institutional and personal incentive to check the executive. Because one, the unchecked ability of the MPs with the connivance of the executive to increase their salaries and benefits when they want. That's problem number one. Problem number two, the unchecked ability of MP through CDF, again with the connivance of the executive, to leverage public money to enhance their own power and to increase their own electability. So CDF helps incumbency in two ways. It helps to ensure that the MPs are re-elected. So MPs are usually, you can see that the MPs who use CDF well are actually usually re-elected. And number two, it disadvantages the potential competitors of those MPs. Now, what price does Kenya pay for this? And this is where I want you to understand the nature of it. Whenever the MPs increase their salaries, the executive can veto the bills increasing those salaries, but it never does. When the MPs want an increase in CDF, the executive can veto the increases in the CDF, but never does. The question is why? And the reason is the following, is that MP salaries and CDF are now the key tools for fiscal bargaining between the president and parliament. MPs bargain away their constitutional duty to exercise oversight in return for executive favors on their salaries and the benefits and on CDF. Just today in the morning, I was listening to the debate on this on the finance bill. And one MP was saying, look, you guys, we agreed last week that the government is going to give you 30 million shillings more on CDF to pass this bill. This is what MP was saying, this on the floor of the House. So how does Kenya lose in this process? This is how Kenya loses. The combined budget for Parliament and CDF is about 2.6% of the budget. That's how much goes to both CDF and the budget of Parliament, 2.6% of budget. The average vote for the executive, on the other hand, is about 54% of total budget. The executive as a whole gets 54% of budget on average. So what we have is the following, that the MPs, in return for getting their 2.6% of parliamentary allotment for CDF and salaries and everything else, they surrender oversight over 54% of the budget, okay? So that Kenya gets CDF projects worth 1.5% of budget, because that's the entire CDF budget. They get projects worth 1.5% of budget, but lose accountability and oversight on 54% of the budget. So in fact, in my thinking, CDF is best named the Judas Iscariot Fund, because this is selling Kenyans for 30 pieces of silver. You're getting this little budget, but you are bargaining away your entire oversight. Because the only reason why this MP would be telling his fellow MPs today that they have got an additional 30 million shillings on their CDF is to say, basically, don't scrutinize this thing. Yeah. So that the first thing that has happened, the capacity of Parliament to do oversight and enforce accountability of the executive is completely neutered because their interests are not aligned with the interests of the voters. This is a fundamental separation of powers question. Yeah. And it is the MPs are saying it on the floor of the House themselves. Okay. Now, let's talk about fiscal constitutionalism and CDF. That is the second issue. The first issue is separation of powers, and we can go back into that and you can drill deeper about what kind of problem that poses. Let's talk about fiscal constitutionalism. What is the nature of the violation? Fiscal constitutionalism, also known as the power of the purse, is vested in Parliament, and it rests on two related principles. The first principle is there will be no taxation without representation. Number two, there will also be no spending without representation. One, no taxation without representation. Two, no spending without representation. If you think carefully about this, it will then explain to you why in many countries around the world, universal adult suffrage, the right to vote, came contemporaneously with the introduction of broad-based income tax. So that the move to increase income tax, to impose income tax, most countries didn't have income tax until the beginning of the 20th century. So that the coming into force of income tax across the world came simultaneously with the right to vote. Because it's a recognition in constitutional theory of the fact that the most important office in a democracy is the office of citizenship. What you have in Nairobi is not a government. It is not the government. The government is the people. What you have in Nairobi is an administration. The president is merely a citizen in office. And the day he ceases to be president, he comes back and continues the office of citizenship. So this is core to understanding the nature of the fiscal violation. Because given those two principles, no taxation without representation and no spending without representation, Parliament should scrutinize and interrogate the executive tax-raising proposals and compel the National Treasury to justify those proposals. Secondly, Parliament should also scrutinize and interrogate the executive spending proposals and seek justifications for those proposals. Okay? Now, there are three fiscal constitutionalism problems that CDF gives rise to. Problem number one is what I call the tax problem. The tax problem is the desire and incentive of MPs to fund their own CDF projects weakens their motivation to slash the executive's tax proposal. And I think this comment by this MP today clearly illustrates this point. He's telling his fellow MPs, there are all these taxes here which a lot of Kenyans are up in arms against. But he's reminding them, you've been given 30 million per constituency. Why do you want to take this away? So that the incentive and desire of the MP to actually question the tax proposals of the government is weakened by their motivation to have the CDF, and especially if the executive were to threaten, this is what I was calling bargaining, fiscal bargaining, were to threaten them by saying, if you reduce the taxes, I'll cut back CDF, which is what the executive could say. Okay, so that's the first problem, the tax problem. The second problem is the spending problem. The spending problem is that collectively and individually, the MPs have no desire or incentive to scrutinize the CDF projects of their colleagues when they are appropriating the money for the CDF fund. So you've got these MPs, they have all these projects. One of the obligations they owe their constituents, and one of the obligations they owe the country as a sovereign power. Remember, I said sovereignty of the people is the foundation of this thing. When they are scrutinizing spending, they're supposed to be asking difficult questions about spending. But they would never question the spending of CDF projects in their colleagues' constituencies. So that's the second problem, the spending problem. Then you have the accountability problem that I think Wanjiru Gikonyo mentioned. MPs have no desire or incentive to scrutinize the Auditor General's report on their colleagues' CDF projects. However criminally involved the colleagues might be involved in whatever scams their colleagues are involved in terms of their CDF projects. So where does that leave us? Then I think there are three conclusions we need to make. We can make. Conclusion number one: in terms of constitutional architecture, CDF is congenitally defective, so far I can see. You can't overcome the separation of powers problems because the MPs are taking an executive function. Even if they baptize it, even if they change how it's managed, the fact is that they are trying to implement projects which they have raised taxes for and voted money for. That's what they're trying to do. They may try to do this remotely. But if they knew, for example, that they could not control what projects were implemented by CDF, they would abandon CDF. So the only reason they have for actually wanting CDF is because they are sure they can control, they can direct where the project. So that's the first thing. CDF is congenitally defective, both on separation of powers ground and on fiscal constitutionalism ground. Number two, giving MPs a paltry slice of the national budget, less than 3%, that is the combined CDF and parliamentary budget, has aligned the MPs' interests with those of the executive, which then has neutered the parliament's checking and balancing power and defeated both public good and sovereign control of the people of Kenya over parliament. The result, which is now where I'm at the final conclusion, is that the executive now has a roving fiscal warrant that has enabled unaccountable budgets and weak and fragmented oversight. I don't think it's an accident that if you look from the day the MPs increased their salaries in 1998 and passed the CDF Act in 2003, there has been very little exposure of big government scandals in Parliament. Goldenberg, there were very many questions raised about the money that Mudavadi had said were customs refund. Maoka Maore in the post-1998 period, but before CDF, was very central to the disclosures associated with agro-leasing. So my thinking is that we can actually see palpable decline in oversight, and you can see it most clearly in the oversight, the weak oversight we have had over debt since the government started binge borrowing towards the end of towards the beginning of the Uhuru presidency. I'm sure that when we come to question time, I can clarify any of those reflections. Thank you.
Where are Ms. Wachira Maina's claps? Thank you very much. Thank you very much, Mr. Wachira Maina. That was a very informative session. You can always trust Mr. Wachira Maina to come with statistics, and he will say something that we will remember. Now I know the CDF is a Judas Iscariot fan. Thank you very much, Mr. Wachira Maina. And we hope to hear more during the plenary session, which begins now. Ladies and gentlemen, it's that time when you engage the panelists. And to start us off, I'd like to invite the avid reader's best friend. This person has been our friend for the longest time, Dr. Gautam Bhatia. I know he's in the audience. He said he cannot possibly miss, and he didn't. We're very happy you're here. I would like to ask you to start us off in the plenary session. Tell us something, ask a question. We are dying to hear your wisdom. Welcome, Dr. Bhatia. Dr. Bhatia, I hope you are able to speak. I know we hadn't given you a warning before, but as our best friend, you must say something.
Sorry, can you hear?
Yes, we can. Yes, we can. Yes, we can hear you.
I was just expecting I'd be listening in, so this is quite unexpected. I put some questions in the chat as well. I was very impressed when I read this judgment. I think it's one of the clearest judgments I've read from any court anywhere in the world, and I taught this judgment in my comparative constitutional law course to my students last month, and they were also very struck by this judgment, because also in India, the Indian Supreme Court, we have a very similar case. So what you have as the CDF, we have something called the MP Lads Fund, where MPs are given this constituency fund, and then they spend it, and it gives them incumbent bias. And in fact, and this was challenged in India in 2010 on exactly the same grounds as the CDF case. It violates the separation of powers and that it creates incumbency bias. And the Indian Supreme Court unfortunately rejected the challenge in a very ill-reasoned judgment. So I contrasted the two judgments in my class, and the students were, they all found the Kenyan judgment far more persuasive than the Indian judgment. So I just wanted to, I put some questions and I wanted to maybe just raise them for the panelists. So I think one was, how would you perhaps articulate the link between separation of powers and devolution in the judgment, the link between these two concepts, how are they linked? And the second one, and this is something I found very interesting, was that, of course, the Kenyan constitution is transformative. That's what we all agree. And what is striking in this judgment is that the way that the court articulates separation of powers, it's in the very classic sense, legislative tasks being oversight, deliberation, and lawmaking, and the constituency is the unit of political representation and not a unit of patronage. So that is a very classical form of separation of powers. And I was wondering, how do we understand transformative constitutionalism and this sort of going back to the basics? Is it because separation of powers was mangled so much in the post-1963 era, where effectively through amendments, hyper amendments, the president began to exercise power through the the provincial agents, completely sidelining parliament, completely sidelining devolution. So in that sense, and Roswell and Dixon calls this restorative constitutionalism. So is restoration of certain fundamental concepts like separation of powers, a part of transformative constitutionalism? That would be my second question. And my last question to Professor Maina, so you mentioned this idea of incumbency bias, and that was what I thought would be a big deal, but what I found interesting was that in the Supreme Court judgment, in one paragraph, they flag incumbency bias as, issue, but it hardly plays, a big role. So they focus much more on separation of powers, on devolution. And I was wondering if you think this was a pragmatic, move, that they didn't want to really go after parliamentarians. So they flag incumbency bias, make incumbency bias as a fundamental feature of their analysis. Because, to me at least, the major problem is incumbency bias. Because if the incumbent, creates these patronage networks, it becomes hard to replace them in the election. So those would be my three questions and observations. And again, I'd say this is one of my favorite judgments, I think, from any court anywhere in the world. I just love the reasoning, the simplicity and the way it's argued. So I found it brilliant. So thank you.
Thank you very much, Dr. Bhatia, for speaking to us. We are happy to hear from you. I'm aware that you have been baptized the Kenyan name. You are Dr. Gautam Omondi. I am very happy that you are able to join us, and we are very happy to have had your insights. And we're very glad that Kenyan jurisprudence is making the rounds in the world and making a difference. This is great in light of the South and the global South making its impact in the legal space in the world. So we're very happy to hear from you, Dr. Gautam. Thank you very much. And now I would wish to open the floor for the audience to give their comments and questions.
So
clarifying that.
Yes.
So the questions will take them in batches. So some questions, and then we'll invite the panelists to answer them. Then we'll do it that way until we come to the end of our session. So I see some people are already raising their hands. Some are already asking their questions in the chat box. Whatever system works for you, it's fair enough. So we can start with Kiserian Amos. I see you already have your hand up. And as you ask your question, if it's a question, not to state which panelist you prefer to answer your question. So just mark that as you make your comments or questions. Yes, Mr. Kiserian Amos, the floor is yours. You can ask your question. Remember, you have maximum of 1 minute just to ensure we have as many participants as possible. I ask you to take just a maximum of a minute to ask your question. Amos, are you able to speak? Amos, are you addressing us? Okay, we can move to the next person as Amos fixes the issues on his end. Meanwhile, I can read a question in the chat box. The latest question that should be Chukwa Titus. Your question is directed to Mr. Ongoya. You ask that, as we are aware, corruption is rampant at the constituency level. What are the legal mechanisms to ensure transparency and accountability at that level regarding the CDF? So that question goes to Mr. Ongoya. We also have a comment by Bernard Omwanzo. He asks if we believe we really achieved what we wanted with the CDF, apart from the change of name, and if our MPs are still in charge of these funds as patrons, and is it the main reason why women reps now have national government affirmative action funds and the Senator's Oversight Fund? He asks us to think about the devolved CDF in the name of Ward Development Fund, and it is almost introducing the fourth function of the legislatures to include the use of the CDF. Okay, thank you. We also have a question by Patrick Osodo. I hope that's your name. Patrick asks, the CDF multi-stakeholder committees that were meant to operationalize the fund right through the ward, village, and project level, what became of them? What is the experience of the functioning of these committees? I would direct that question to Mr. Ongoya. And we have an anonymous attendee who asks, hello, my question goes to Shiru Gikonyo. Can you relate to the CDF Act to the current NG-CDF Act? How is the MP involved in the running of the fund, as the Act makes it seem like the MP is not involved at all except as an ordinary constituency resident? Perhaps we can get answers to those questions, and then we can have another round of questions and comments. So I'll start by inviting Mr. Ongoya to give his responses to the questions. Welcome.
Thank you. I hope you can hear me, Marion.
Yes, we can.
For good order, I will just pick a few so that I leave the rest for the rest of my colleagues. The interplay between separation of powers on the one hand and devolution, I'm hoping I got Professor Gautam Bhatia's question right, and how they informed this judgment. As you can imagine, and I think Prof. Gautam, you mentioned this, the court framed the principle of separation of powers in its simplest manifestation, in its most traditional casting, how separation of powers is and what the roles of each of these powers are. And the court observed that when it reads the architecture and design of the Constitution of Kenya 2010, the role of the unit of representation in parliament is the constituency. And the role of that unit is representation and oversight, and not service delivery. And the court then said, service delivery is a function of the executive structures in the national and county levels of government. The most conservative, the most basic, the most traditional possible understanding of the doctrine of separation of powers, perhaps in the Lockean, Montesquieuan sense of that word. So that is the context. But roping in devolution and the interplay, because the court observed that if we implement CDF as structurally designed, it compromises an element of fiscal discipline, financial discipline, which is supposed to run through the national government and the county government by compromising, number one, a unit of oversight, that is parliament, by compromising it. And I think my colleague, Mr. Wachira Maina, did duty to that in the multiple manifestations. Mr. Wachira Maina, let me take advantage of this to say that we will need a recording of your presentation in our next court appearance, or that we play it as part of our submission. But having said that, let me leave the rest for Mike. Okay, on the question of restorative constitutionalism, let me put it this way, Gautam. Our courts speak funnily. And I think that's what Ochiel Dudley meant when he said, this is the clearest judgment of our Supreme Court he has read. I didn't understand him to mean that this is the only judgment of our Supreme Court he has read. It means the others are not clear. I understood him suggesting that the other judgments are not clear. And having sat through the traditions, the writings, the jurisprudence of our Supreme Court, I won't personally be surprised if I come across another judgment of our Supreme Court today, tomorrow, or in the future, stating these principles fundamentally differently, and even departing from them without disclosing that it is departing from them. In fact, by asserting that it is complying with these principles. And that puzzles me all the time when I read our Supreme Court jurisprudence. This is not the time for me to delve into the details of examples, but I've given you a lot of decisions of our Supreme Court on basic administrative law issues, where the court is departing from its earlier position while stating that it is not departing. And you keep wondering, when does a departure amount to a departure? So the court here appears to be stating a very conservative conceptualization of separation of powers. But this court, if you analyze its other judgments, you will come across a transformative version of separation of powers. So you don't see a clear philosophy of law emerging from this court simply by reading this single judgment. One needs to read a multiplicity of judgments to see whether there's an emerging legal philosophy from this court on whether it now wants to cast itself as a court that restores the traditional conservative understanding of separation of powers. Let me just deal with Mr. Chukor's question. In fact, that's precisely what I understood Mr. Wachira Maina to be saying, that the CDF Act has entrenched through the instrument of law the element of corruption in multiple ways. First, is a tool of bargain by the executive. We want more money to misappropriate. So we'll give you some 30 silver coins, so long as you give us the rest of the billions. That is corruption. And number two, every member of this platform sitting here knows that there have been multiple instances where governors have been summoned before Senate, for example, to answer various questions arising out of the audit reports of the Auditor General. A question then arises, how come we have not seen a similar number of CDF managers appearing before Parliament to also answer those questions? Even if no action is taken against them, but at least at that level of just answering questions, why don't we see a similar number of CDF managers? This is how incestuous the relationship between the oversighter and the person who is supposed to be oversighted is in respect of the CDF fund. And that's how blurred the lines of accountability are. To Patrick Osodo, yes, ideally, the way CDF was thought out was that these projects were supposed to be the classical bottom-up approach. There were supposed to be sub-locational committees, locational committees, ward committees that originate projects before the CDF committee at the constituency level now prioritizes them, sees which ones to give priority so that they are distributed evenly across the whole constituency. But you and I know that the member of parliament, first of all, designs the projects in accordance with his campaign manifesto, then now takes them down to his hand-picked members of those committees for formal imprimatur. Then the minutes will be generated to say that these projects have come from the committee. I mean, it's amoral. And I think that if we have to design a sustainable governance model, members of parliament must go back to their original role and do it ruthlessly so that the executive arms in the national executive and the county executives are held to account more optimally. I will stop at that and allow my colleagues to take up on the remainder of the questions. Back to you, Marion.
Thank you very much, Mr. Ongoya, for those well-detailed answers. I'd now like to invite Ms. Shiru, if you're ready to answer the questions. Welcome.
Thank you so much, Marion. I'm ready. And I just want, if you would allow, to acknowledge our co-petitioner, representative of the institutions that we've gone to court with. I've seen Cornelius Oduor, who is the former executive director of CGG, and we have journeyed together in this case. He's now with KHRC, and KHRC have not enjoined on any of the cases, but I think they may have enjoined on the NG-CDF one. But again, we've been journeying together. So just to acknowledge that he's on the call. So the question that came to me, and then I wrote it down in a very abbreviated form. So oh yes, it was a question about the CDF and the NG-CDF. And then if you'll allow, Marion, I'll just make a quick input on some of the other points. We can't say much on the NG-CDF because we have a case in court on that. But yes, our sense was that what Parliament did and what they've done over time, and I think Wachira spoke to that and Elisha spoke to that, is that in response to successive court rulings, they have amended, they've continually amended the law. So in fact, there's a political accountability question, and I believe Wachira has spoken substantively about the incentives, but there's also a question in my mind, because this is, Parliament continually evading the court rulings by making these small adjustments, at a really high cost, because, so from an accountability point of view, from a legislative point of view, how do you deal with this? But really, it's a political accountability question. And part of the, reason I felt it's useful for us to have this discussion is to really think about where are we now? And how do we deal with this? Are we going to litigate again all the way to the Supreme Court and then another fund all the way to the Supreme Court? So how do we deal with this? So we can't say much about NG-CDF other than Parliament has really been very ingenuous or disingenuous, responded to things and really made it very palatable. But the fundamental challenge remains. I think on the issue of these committees, it's very ironic, as Ongoya has said, yes, there are these, what CDF has done is it's opened the incentives to include citizens, because projects, at project level, they have these thresholds. So at project level, you've got contractors who are eligible to get these contracts. So CDF is a very inclusive procurement fund. And this is why it's very popular. And that is why you seldom hear disaffection by citizens about incomplete projects, because even though they are incomplete, the procurement was done locally. So on one hand, the CDF pushes money to the ground, which is great. But unfortunately, because it's incestuous and because the incentives are distorted, the citizens are also part of this, this corruption, so to speak. When we started out the case, we did a bit of an assessment because we wanted to do PIL with a lot of citizen engagement. We wanted to sensitize them on issues of separation of powers and functional roles and all of that. And we found we couldn't because the ground was opposed to what we were doing. So actually we focused only on the court with minimum of sensitization. Sensitization normally we would do at the national level, but not on the ground. But of course, now with our debt crisis and our financial crisis, it may be the right time to reopen this discussion and say, listen, you have to deal with the basics so that you can get your good results. And I think Wachira has done very well to give us some good arguments on that. Entrenched corruption, yes, CDF is a patronage fund. We strategically very early on made a decision to focus on the legal arguments because arguing corruption in our courts, there's a lot of legislation, but if you look at the jurisprudence, it's really hard to win corruption arguments. And we felt with the resources we had, we were better off focusing on the constitutional arguments. So that is why we took the stance we did. And then the last point is, indeed, CDF has opened the way for other funds. We didn't fare well with the Women's Fund, the National Government Affirmative Action Fund. We lost that case and the High Court ruled in favor of the fund, and we felt, okay, tactically, affirmative action is a sensitive issue. We all support it in principle, and we left that one. But of course, there's the Senate Oversight Fund, there's the County Assembly Fund that Parliament now wants to entrench in the Constitution so that it will be complete. All the legislators will be in on the action, the citizens are in on the action. So this undermining of our constitutionalism, our fiscal constitutionalism, Parliament is seeking to enjoin all the key actors. So we really need to, it's good we are getting good arguments. We also need good theater and good strategies on the ground so we can make the case. Otherwise, CDF threatens to really undermine the foundations of constitutionalism. On separation of powers, I won't even try and make a legal argument other than to say, parliamentarians have been wont to say that this separation of powers is a Western concept. It doesn't work in the African democratic situation because citizens require projects. They need to see the MP implementing, otherwise they'll vote the MP out. In a way, this is true, but it has to do with a need to sensitize citizens and possibly a need to look at what kind of elective system, representative system works for us. So the CDF might open up this discussion about, whether we stay with the presidential, whether we need to go to a more parliamentary system, the role of the MP. Is it really fair to have an MP elected at a constituency who then comes at the national level and can ignore the needs of citizens? So I think this case is so interesting. CDF opens up so many lines of interrogation around our constitution and representative system. And I think it's very enriching to have this conversation at this time as we re-strategize on the case. Thank you.
Thank you very much, Ms. Gikonyo, for that detailed response. I'd now like to invite Mr. Wachira Maina to give his responses. Welcome.
Yeah, thank you. I think some of what I was going to say has been said by Bwana Ongoya, so I won't go over it. I think this point you're making, Dr. Batia is making about incumbency bias. It didn't find its way in the judgment, and I wonder, and maybe Wanjiru can tell us, maybe it was not litigated. I'm not sure whether it was litigated or not. Maybe the reason why it isn't there, because it's obviously, if you're talking about a free and fair election, and you've got these people with this bulldoze of cash from the public purse, using it and leveraging it for the purposes of elections, whether that really can count as a free and fair election in the constituency. But we can develop that argument, I think, as we go along, Wanjiru, in this case that you're now litigating. I see a question posted about, can the benefits arising from the CDF outweigh the oversight failures? Actually, no. CDF only takes 39 billion. CDF is only about 39, max 40B. The counties, in contrast, are taking 350B plus. And the national government is doing 1.88 trillion, more than 1.88 trillion. Actually, now this year is actually more. That's last year's number. Out of which 550B plus is development budget. So it seems to me that if MPs are giving the executive a through pass on 550 billion development budget because they are being given 39 billion, it is no wonder that when you read the Auditor General's report, like the ones I have read, I saw one, I think 2 years ago, where the Auditor General said that the national government had lost in excess of 400 billion shillings. So in other words, the executive had lost 10 times more what CDF got. So why did the executive lose 400 billion Kenya shillings? I have no clue. Maybe it's because the oversight was weak, and maybe the oversight was weak because of CDF and personal salaries of MPs. So the point is this: if you've got a system built around the separation of powers, and one department of government is not conducting its function of oversight, you cannot, of course, attribute the losses directly to that lack of oversight. But clearly, the fact that the oversight is not being performed is not an irrelevant fact. It's not an irrelevant fact to that issue. And this is my concern. My concern is there is so much financial monkey business going on at the level of the national government and the executive, that I am not sure that it is not because Parliament is failing in its oversight. That's number one. Number two, there are cases in which I know Parliament has actually failed in oversight. For example, authorization of debt. Virtually none of our debt is authorized. The government has this very sneaky habit of getting Parliament to raise the ceiling. But raising the ceiling is not the same thing as approving debt. You're just creating a capacity. Raising the ceiling is creating a capacity for borrowing. It is not an approval of a particular debt that the government is taking. So I think there is a whole debate we need to be having here about why is Parliament not actually doing its fiscal responsibilities with reference to debt? Is it because of the payments they are getting out of the CDF and their own salaries, or what's going on? Yeah. So that's the second comment I would like to make. Now, the second, I think that one of the second issues that that issue that I'd like to address is this question of I think it was a combination of things that Dr. Bhatia was talking about, tied back to the link between separation of powers, devolution, transformative constitutionalism. And I was going to say, one of the reasons why I've been a little hesitant to comment on this case, good as it is, one of the reasons why I'm a little hesitant to comment on this is that the Supreme Court has a fire department approach to cases before it. It's a sort of jurisprudence, is a fire department jurisprudence. One day there is a really good judgment, the next day there's a really bad judgment, and it sort of keeps flip-flopping. So that I think they haven't recognized that the Supreme Court is supposed to be the home of transformative constitutionalism, because there are two pathways to transformative constitutionalism, two main pathways. There are many more, but there are two main pathways to transformative constitutionalism. One of them is devolution, the other one is Article 34 rights. My reading of the Constitution is the government should be doing rights-based budgeting. It doesn't do rights-based budgeting. It should be doing that. And the court has the tools in the Constitution to actually interrogate. And I can give you an example, like the Mitchell decision. The Mitchell decision, one of its fundamental failures, the court did not see that the violation of the principle of non-retrogression is a violation, because non-retrogression is a duty under Article 34. So if the government takes action that brings a person down below where they were before, that is a violation of Article 34. So, and I think there is a certain, how should I say, standard understanding of the nature of the duty of transforming that is embedded in the Constitution, and that the Supreme Court should be at the leadership of. Thank you.
Thank you very much.
Thank you very much,
Ms. Wachira Maina, for your presentation. I'd now like to. Can you hear me? Sorry about that. I'd now like to invite the second set of questions and comments, and we can start with Emmanuel Miller Oyugi. I believe you have a question. Emmanuel Miller. Okay. Emmanuel Miller, you're able to unmute now. I believe you can ask your question. Okay. As Emmanuel fixes his issues, I can read the next set of questions. Maybe to also note that we have an audience on YouTube. This event is also being live streamed on YouTube. And to our YouTube family, we are happy that you made the time to join us. We're very honored. And we are happy that you have questions and comments. So I'd like to begin by reading some. Nyamosi Edwin says, it's a superb presentation, which begs the question, how do we go about educating the masses? That should be civic education. I will direct that question to Mr. Ochiel Dudley. And we also have Peter Young Green, who is asking, if we have a problem in having the parliament exercise oversight, is there a way that we can use the independent commissions and offices as watchdogs? I'll direct that question to Mr. Wachira Maina. We also have some questions in the chat box. We have a question from, that should be, no, Chukor titles, I believe you have been answered. Kipngetich asks, with regard to the doctrine of justiciability, what are the responses as to how the Supreme Court applied its mind on the same? This question is directed to Mr. Ochiel Dudley, I believe. We also have another question. We have a comment by Michelle Herring who says it's a great piece. We have a question or comment from Patrick who notes that this is really useful. How do we generate loud, public, impactful discourse around this fund? Because where it has been implemented effectively, it has filled real gaps at the local level. I believe I can direct this question to Ms. Wanjiru Gikonyo. We also have a question from Cornelius Oduor, which I believe has been answered by Mr. Wachira Maina. Thank you. We also have another question from Patrick, who asks if there is a link between CDF operationalization and the much bandied but poorly codified institutionalized citizen participation law. He also asks this one to Mr. Wachira Maina. In the end, are citizens agents not, so in the end, is citizen agency not really the issue? Yeah, we have another question from Brian Wabala, who first comments that Mr. Wachira Maina has made a compelling presentation on the diminishing parliamentary oversight, which is nothing. If nothing is done, we may never experience any change. What do you propose to be done to remedy the situation? It appears that it will be difficult to take the MPs off the funds. Bernard Omwanso notes that the strongest link the MPs have is the common Mwananchi's understanding on the role of an MP. Most of our MPs are surviving politically because of these funds. Is it possible to approach this question from a civic education level? We also have a question from Kipkorir Caleb. I will direct this question to Mr. Ochiel Dudley. Knowing that development is a key factor in determining whether MCAs and MPs are re-elected to Parliament, how do we balance the need for development and the MPs' access to these funds? How do we solve the problem experienced by the introduction of CDF? We have another question from Bosire Bonyi. This is directed to Mwalimu Ongoya. Bosire asks, for impatient patriots like himself, they understand that sometimes it takes time to achieve constitutionalism and the rule of law. What must we do to fast track this process? It really hurts that unconstitutional actions keep improving several years later after they were declared unconstitutional. We now have a budget to increase CDF allocations. Why must the rogue prevail for this long? It makes us sound very academic rather than practical. Thank you for your questions so far. Mr. Ochiel Dudley, if you are ready, we can begin the second round with you.
Okay, thank you so much. This issue of CDF was introduced by, I think, an MP called Engineer Karue.
Yes.
And yes, that's Karue.
Yeah, that's it. That is actually it.
Yeah, is it the Nyandarua? I think Nyandarua MP. Yeah. His issue was decentralization of funds, because initially we had on budget day and on other occasions, you'd have an MP in Parliament standing to ask maybe the Minister for Roads or Finance when the bridge across River Gay, where I come from in Kokoro, would be constructed. And the answer would be something like when funds are available in the next budget cycle, because consistent with that kind of budgeting or centralization of public funds, we also had the issue of political correctness, Siasa Mbaya Maisha Mbaya, and the earlier sessional paper, where funds would be sent to areas with high potential. And these are the former white highlands. So you'd have places like Turkana that do not have a single kilometer of tarmac road so many years after independence. So the first attempt, one of these attempts at decentralizing funds so that the country can develop equally was CDF. But then Kenyans perfect that attempt at decentralization in 2010, when we now have devolution with the counties, complete with county executives and complete with county legislatures, with competence to drive devolution within the counties. And if you look at Article 174, 175, the aims of devolution, the objects and principles are stated there. So then, but then the CDF does not end with the entry of devolution. It should have ended, so that we now focus on devolution, on building the counties, and we focus on development at the national level. So the problem that CDF meant to address is now addressed in a better way, complete with oversight mechanisms, the county assemblies, and then the Senate as a second layer. The issue that the other problem that CDF now causes is that it gives MPs the corrupt incentive to deprive the counties of funding, because the CDF formula for a long time has been it's derived from a share of the national government revenue. So that the more the national government has in the national budget, the more MPs get for CDF. and we've had stalemates over the share of counties because it's dependent on how much MPs give the national government. Obviously, and then also just to mention, Prof. Wachira, the issue of incumbency benefit is addressed in the decision at paragraph 127. The court does not expressly use it to nullify, but it recognizes and addresses it. And Mwalimu Ongoya was saying that it's one of the clearest because I've read many others. Some I dispute on some grounds, but I do not find any grounds to dispute this judgment, including on the one that we lost on mootness. Because I understand the court to be saying that if they had addressed the issue of mootness and said that this matter is moot, then their decision on the merits would be questioned, the way we question Sonko. Why did the court go on to address it, despite finding that it did not have jurisdiction? So for me, it's one of the clearest ever decisions of the Supreme Court. It's logical, it makes sense, and I agree with it entirely. Let me give you a little bit of tea, now that you're talking about Gen Z, on how Ongoya came to argue the case, and I'm grateful he did. The judgment, I believe, is that clear because it was informed by the always lucid arguments of my mentor, Mr. Ongoya. When we were just about to argue the case, a few weeks to, could have been 2 weeks or maybe 3 weeks to, I told Shiro to bring back Ongoya to the case because the other senior counsel we were arguing with was not available. And Ongoya tells me, no, I can't work with Shiro because I began this case, na tulikosana midway. Then I tell him, Ongoya, you're the perfect person to finish it. And he came and we made the arguments that we made. And I'm really happy that Ongoya, came back and that I helped to create peace between them, though they have not given me tea for that. That's just background tea. Some of these cases, when you present the case, sometimes you have infighting in the legal team. Those are the things you do not see. You just see the judgment and you see the products, maybe the arguments, but you do not know some of the arguments that happen behind the scene and how they inform the decision of the court. Thank you so much. Mwalimu, I hope I have not given TMI too much information. That's Gen Z speak. Thank you so much, Marion.
Thank you, Mr. Ochiel Dudley.
He's a bad lord. He's a bad man.
Mr. Ongoya likes to use this phrase of determining if people are fundamentally good people, like in their heart of hearts, even if they have made mistakes, they have messed you up here once in a while, but are they fundamentally good people? According to Mr. Ongoya's comments in the chat, which in verbatim says Ochiel is a bad man, I don't think you'd be passing that test, Mr. Ochiel Dudley. And with that, I'd like to invite Ms. Shiru to respond to the questions that were directed to her. Then we can proceed. She can also give us some more tea. We are here for it.
We are spilling the beans. And,
yes.
And yeah, maybe I'll start with our falling out, which I must confess, as far as I'm concerned, it wasn't so much a falling out as a difference of opinion about how the case should go. And I think we were, Ongoya coming back really happened at a time when we needed that energy, that input. And so I'm very grateful that I kept reaching out to him. Every time we'd move to the next level, I would reach out to him and he wasn't taking my calls. So Dudley, I definitely, I owe you big time. And so it worked out. I would like to request Marion, if it's not too out of order, to allow my colleague Cornelius to speak to the issues that were raised. There were questions around the citizen agency, the civic education, and really how to politically get the MPs off the fund, maybe he could give us his top level, his thoughts, because like I said, we journeyed together. And if there's anything I feel he hasn't said, I'll add very briefly. It's a practitioner's perspective, the perspective on the ground. So I don't know if Odwar is ready to give let us hear his thoughts.
Yes, Ms. Shiro, that's in order Cornelius can address us. Also, just to note that Mr. Ongoya has noted that you are a fundamentally good person.
I'm doing better than Dudley at this rate.
Yes,
Thank
you're
you.
way better than Dudley. It's settled. Welcome, Cornelius.
Yeah, thank you. I think I've really enjoyed the discussions. How do you deal with the situation? Because I'm really disturbed by the fact that the damages that CDF has eventually caused in our democratic governance architecture is really confounding, because to the extent that members of parliament today cannot objectively engage in a sober debate on issues of national importance, and this can be traced to the conflict of interest that is we see in their desire to have more resources retained at the national level, or to indirectly benefit CDF allocations is really sickening. But we belong to this school of thought that we can only make members of parliament to understand things when we go to reach out to their weakest point, the mwananchi, the voter. If we get people to be sensitized to understand that members of parliament have a bigger role than coordinating development in the constituency, then we stand a benefit of changing the discussion and the narrative, and possibly having a transformative change that can probably remove CDF and all other related funds from the members of parliament, and maybe even now the senators and MCAs, as they're called. So I think what we need is to create some level of consciousness among citizens and voters, so that they are able to up the game and look beyond the short-term material benefit in a way that now they can put members of parliament to play their real the role of oversight, representation, and legislation. So it's going to be a long-term project to sensitize mwananchi, to sensitize the voter, and if possible have either have the constitution changed or have a ruling at the level of the Supreme Court that can actually overturn and remove these kind of frameworks that distort our principles of democratic governance. So it will require that we invest heavily on a political project that seeks to conscientize the public, and eventually have a leadership that can see beyond tokenism and allow parliament to be what parliament is supposed to be. So that will require a bit of political education, and to be able to leverage on that level of the level of sensitization, so that we have real change in terms of how we govern this country. So what I'm appealing is that civil society and other actors, and more importantly now the academia, if we can invest heavily in political education, then we can have a new generation of people who can see things differently. And there lies our real potential to overturn things. Otherwise, I see this problem being very, very, very systemic, because removing MPs from CDF or removing CDF from MPs will not be an easy thing. Thank you.
Thank you very much, Mr. Cornelius. I'd now like to...
Maria?
Yes.
Can I just add very briefly? And
yes,
you know,
please.
I think this would have even been my closing remark, because so much has been said. On top of, as part of this project, The process of transformation requires a replacement of the failed system. So far, we've been reacting and fighting against. From an advocacy point of view, that's what you do. It's you resist and you try and get compliance by the actor. But the process of transformation requires replacing. And I think that's what Cornelius was alluding to. And we need to envisage, what does effective local governance look like? Because county governments have not decentralized. Citizen engagement at county level isn't working properly. And our electoral process isn't working properly. So part of this political project has to start with a vision of where we want to go. And then, come back and say, so what do we need to fix? And I suspect it will include constitutional amendments to take out some of the gaps that exist in the representative process, and maybe even in the citizen agency, the citizen voice. So I just wanted to add to that and really echo what my colleague has said, that this is it's a single case that has so much potential and significance to constitutionalism and democratization and devolution and effective governance in this country. Thank you.
Thank you very much, Ms. Shiru, aka a fundamentally good person. Thank you very much. I'd now like to once again invite Mr. Ochiel Dudley, whom we have established is not a good person, to respond to one pertinent question that he was yet to respond to. And maybe he can defend himself. Why should we consider you a good person now? Welcome, Mr. Dudley.
Thank you so much. The question is about the court's analysis of the issue of justiciability. Well, when I was beginning, I mentioned that the Court of Appeal had said that we had created an hypothetical case and then argued that hypothetical case. But then the court, because there was no dispute between the two organs of government, but then the court at the same time says that this non-existent dispute, we should have taken it to the Intergovernmental Dispute Resolution Forum. Although the petitioner was not an organ of government and has no standing in those fora. And then the other issue, and maybe that's the only one the Supreme Court does not address, is a political question doctrine. The Court of Appeal said that in any case, the dispute, remember this is about the validity of an act, was a political question that the court had no jurisdiction over. The Supreme Court does not address that. It records our arguments, but it doesn't address that. And I think that there's a contrary decision that the Supreme Court has made on the political question doctrine. And so perhaps it chose to save that dispute for another day. But the part that it addressed, we are happy with. It dismissed the arguments about Intergovernmental Dispute Resolution Forum, and also dismissed the arguments about ripeness. The Court of Appeal had said because there's yet no dispute between the organs of the other branches of government, the dispute is not ripe for resolution. It reminds me of this jurisprudence around threats as justiciable. Once someone does not have to wait, the courts have said that. And here you had an act of parliament that was passed and was being implemented. Another tidbit about the case is that one of the Court of Appeal judges retired without ever giving us the written proceedings. So we had to go to the Supreme Court to beg for exemption to be allowed to proceed without that written judge's set of proceedings. Without those proceedings, the record was incomplete. And I think that's why the matter sat around for quite some time. Filed in 2018, argued sometime, I think in May of 2022. It sat 4 years silent before the Supreme Court. The court clears its cases faster than that. That's another tidbit. Marion, there's someone in the chat who says they have an experience with the incumbency advantage. Mr. Maina Kairo.
Thank you very much, Mr. Dudley. Did I cut you short?
No, I'm done. Thank you so much for the opportunity.
Thank you. Thank you very much for your responses. We still note that you are still not a fundamentally good person, but it's okay. We will accommodate you. I'd now like to invite Mr. Wachira Maina to give his responses and thoughts on the questions asked. Welcome, Mr. Wachira Maina.
Thank you, Marion. Now, there was a question about the role of independent offices and whether they can do anything about this. Now, unfortunately, I don't think they can. Anytime the independent offices have tried to do something that disagrees with Parliament, Parliament has responded by cutting their budget. There was the SRC, which tried to cap some of their benefits. And that period when the SRC was trying to cap the benefits of MPs, the MPs responded by cutting the budget of the SRC, the CRA, the Commission on Revenue Allocation, and the following year, they reduced the budget of the Office of Auditor General, which is bizarre because the Auditor General is an auditor for Parliament. So you would think that they would want to empower their auditor so the auditor can do a good job of giving them reports. He's not an auditor for the executive, he's an auditor on their behalf. So I don't think there is room in independent offices to rein in this spending from this failure of oversight by MPs. So that goes to the question that was asked: what should be done to take the MPs off CDF? I think if you are to be really, really sneaky, the best way to deal with this problem is to say the Kenya Constitution establishes two fiscal units: a national government and a county government. Accept the principle of a constituency fund, but tell them it's either a constituency fund that goes to the accounts of the county government. In fact, even increase it. It goes to the accounts of the county government, but it's ring fenced. It's ring fenced so that it can only be used in the constituencies in that county, or make it a conditional grant at the national government level. And you can bypass the MPs by saying the proposal is to increase the vote, and you can call it the open constituency fund. Is to increase the vote that goes to the constituency, but remove it completely from anything to do with the MPs. So that if they are saying that the problem is that this money is, the issue is that this money is being used for development, yeah, there's no reason why at the national level you cannot target a constituency for development, or at the county level, target for development without involving MPs, so they can focus on their oversight responsibilities. So that the issue then becomes that we do not. It's going to be difficult if you keep asking them to reconfigure ways of making the Constituency Development Fund palatable, because this is why they are tinkering at the margins. They should just get out of any business that involves execution. They should get out of anything that involves execution and leave that to the executive, and they focus on their oversight role. I think the issue of justiciability, which I wanted to respond to, has been dealt with by Dudley. I had a thing I wanted to say. Yeah, I mean, this is the point that Cornelius was making. The fact that some education is required to persuade the voters that MPs have a bigger role. But I think the fundamental issue really is to point out to voters that this token amount, this 39 billion that you're getting from CDF, is blocking you from asking questions about the 550 billion development budget. And in fact, the development budget would be much bigger. It would be 1.5 trillion plus if the government wasn't paying so much money in debt. If our debt was smaller, our development budget would be in the order of 1.5 trillion plus. So that by focusing our attention on CDF and the little things CDF is doing at the constituency level, we are not asking any questions about these bigger amounts that are being spent and wasted in ways that we are not able to discover, because those who should be discovering them for us, the Auditor General, working through parliamentary committees, are not discovering or reporting what they have discovered about the wastage of the national government on this larger issue. Thank you.
Thank you very much, Mr. Wachira Maina, for your response. I'd now like to invite Mr. Ongoya and that will be the final round of answers. Mr. Ongoya, there were some questions that were directed to you. I invite you to respond to them and also to tell us more about this field that you had with Ms Wanjiru Gikonyo. We'd like to hear your side of the story in the spirit of fair hearing. So welcome, Mr. Ongoya.
That feud was a creation of the mind of Ochiel Dudley. It didn't exist in the real world. So that answers your question finally and definitively. Now, let me come to the question that was posed by Mr. Bosire Bonyi, which is, I think, to me, who deals with young people on campus every day. I like dealing with this question. The young people ask me this question every time. How can we see the results of this discourse tomorrow? Now, that is inconsistent with the nature of transformation. Societal transformation is a lifelong experiment. It's not something that you brew like instant coffee. It is the price to pay for good governance, the price to pay for the rule of law, the price to pay for constitutionalism is eternal vigilance. You must commit yourself to this cause forever. So, Mr. Konyi, to your question for impatient patriots like yourself, my answer is become patient. Understand that these things take time. Understand that full realization of the concepts of the rule of law and constitutionalism is not something that any society anywhere in the world can say they have fully realized them. Every society continues with these challenges as a going concern and passes the baton from one generation to another. And therefore, you are about to see unconstitutional and illegal actions in your society for a little longer, perhaps as little as until you go to the grave. You'll pass over the baton to your son and to your son's son, or your children's children, so to speak. So the point is that you must do your part as you move on. Years of struggle. I have told people that if you look at the real landmark cases that have been there, say in the realm of socioeconomic rights, Satros Ayuma, which I was involved in at the drafting stage. Satros Ayuma didn't live to see the fruits of the case. She died before the case was concluded. If you go to South Africa and you look at cases like Sobremani, like Grootboom, those people died. Grootboom died before she got her house. Although she got the Constitutional Court declared the right to housing, she never saw the house. Sobremani died of kidney failure without realizing the right to health herself. And therefore, the way you engage in this struggle is like the way somebody plants an indigenous tree. When you plant the tree like, the Elgon teak, you don't plant it in the hope that you'll benefit from the shade under it or the timber from it in your lifetime. You plant it for 3 generations after you. So you invest in this struggle in that manner. And therefore, for Mr. Bosire Bonyi, I beseech you to invest more in the software of patience in this struggle, knowing that you just maintain for us the tools of the struggle and pass them over to the next generation. Slowly and incrementally, our society actually ends up getting better. Those who have been on the trenches for long know that when they saw young people participating in street protests, yes, and getting arrested, Reverend Dr. Timothy Njoya was being whipped on Parliament Road with a man called Liehotio. They have seen our society grow. The only person who was badly injured, sadly for me, is a policeman whom a tear gas in his own hand. And I think we see a society grow. It takes a lot of efforts of people who have come before you and takes you to join the struggle and to pass over the baton to another person and inspire younger people to take up the cudgels of the struggle when you get tired yourself. So the struggle is a lifelong struggle. Maybe just as I close, Marion, let me thank Ms. Shiro for partnering with us in the Avid Forum to make this conversation even possible. And let me thank our multiple participants who joined online, both on Zoom, on YouTube and other platforms to make this event a reality. And let me thank our philosopher, Wachira Maina, for volunteering to join us. This debate would have been bereft of philosophical underpinnings had he not volunteered to join it. Maybe we would have had a very dry conversation. So I beseech him to bear with us and be present a little longer because we are going to engage him a little more. We want these philosophical discourses to spice up these legal arguments as we get along with the Avid Forum. Thank you so much, and back to you, Marion Joy.
Thank you very much, Mr. Ongoya. Thank you for the words of wisdom that you have given us. Indeed, transformation is a lifelong experiment. Thank you for that. Also, I have to thank you for clarifying and giving us more tea on the tea that we already had. Thank you for clarifying that it was a non-issue. Thank you very much. I'd now like to read the final comments from members of the audience. I'd begin with our YouTube people. And on there, Evans Odhiambo Okech notes that it's a great presentation. The CDF fund is a great idea, especially educational bursaries. However, the level of nepotism and favorism in allocation of the bursaries is at a level never seen before. Fair enough, Evans Okech. We also have Philip Omodi, who notes that it's a very informative session. Atunga Atuti, who notes that it's a great discussion. He is impressed by the quality and clarity of the presentations, and he congratulates Kabarak University. Godfrey Ngamao, timely and excellent discussion. Thank you all for your participation. Bosire Boni notes that he will immediately download and install all that software of patience as soon as possible. Emmanuel Miller notes that it's a very great discussion. And I could not agree more with all of you. I'd now like to move us to the final session, which is the closing remarks. And I'd start by inviting Ms. Wanjiru Gikonyo to give her final remarks. Ms. Wanjiru, if you're ready, welcome.
Thank you very much, Marion. And I'd like to start by really appreciating the partnership and the collaboration. And I'm glad we were able to ventilate those issues that hadn't seen the light of day, and to ascertain that there was no bad blood. More to that, this conversation has been very enriching, very helpful. And as Mr. Ongoya was speaking, he actually preempted my closing thoughts, which was going to be, we went to court first in 2012. It's now 2024. At the time we started, and part of the reason Ongoya and I would have had a bit of altercation was that point of impatience. So sitting where I am now, I realize this is a journey. And this is actually looks like a midpoint reflection for us to re-strategize and now take us a transformation approach. Because before we were taking a litigation approach, a constitutional litigation approach, now we want to do as a constitutional transformative approach. And so this, I find this extremely helpful. And again, I'll mirror what Ongoya said. Yesterday, seeing the Gen Z step in, where they say their leaders have failed them, their representatives have failed them. They have now come in and stepped in and taken charge, and they brought a new type of activism. Gives me a lot of hope. And it tells me that Kenya is changing. The real owners are standing up. Citizen agency is becoming real. And as we recalibrate, those are the reflections that I'll be having on my mind. Also, passing the baton is will be built in to whatever next steps we have on this case. And I take the point, as Elisha has said, has well articulated, that the fruits might not be enjoyed in this generation. So we have to prepare ourselves for a longer charge. So thank you so much for the reflections, as well as for the tea, which has been equally informative.
Thank you very much, Ms. Wanjiru. I'd now like to invite Mr. Ongoya to give his closing remarks. Welcome, Mr. Ongoya.
Thank you. Thank you, Marion. I think I had largely dealt with that, but made this idea realize discussions coming. Let me tell our audience, wherever they are, that this is just a tip of the iceberg. In this series of conversations that we are partnering with Wanjiru Gikonyo, we have a series of debates, of discussions, of conversations that are lined up, and therefore this was just an appetizer. The real meal is on the way. Whet your appetite, because it's up to quite some scratch. I thank you so much, and long live the Avid Readers Forum. Back to you, Joy.
Indeed, long live the Avid Readers Forum. Thank you very much for convening it. I'd now like to invite our Mr. Ochiel Dudley, who I should mention that is a resident by now. You have been with us for quite a couple of sessions, and you are a resident by now. Welcome, and we are looking forward to your closing remarks. The floor is yours.
Well, thank you so much. I think I would also just remind citizens that the price of liberty is vigilance. We need to be vigilant. And I'm grateful to the person who proposed this current finance bill, because it has made many of us realize that there's something called public finance management out there. There's something called finance bill. And people are now following National Assembly debates and giving instant feedback. Some of it they give directly to the member of the National Assembly. So what's going on is what we needed. We need it because it was time to reset National Assembly. It's meant to be an organ of oversight, but sometimes you see them saying no CDF, no budget, and then whatever the government wants to do, national executive wants to do, it only has to dangle the CDF card, and then it gets whatever it wants. So the fact that the citizens are now have become more active in the processes and are questioning actively is commendable, is a kind of reset that we needed. I think maybe the next debate would be around the issue of recall. And that discussion, people are asking, I see more actively about recall, and perhaps that's the next conversation we need to have. Thank you for having me, and thank you so much, Mwalimu, for the engaging discussion, and everyone else. Thank you.
Thank you very much, Mr. Ochiel Dudley. Indeed, the price of liberty is vigilance. And now I'd like to invite our statistician, philosopher, and lecturer at Kabarak University Law School, Mr. Wachira Maina, to give his final remarks. Welcome.
Gosh, I wish I was a statistician. It's the one thing I envy my economist friends, because If I was a statistician, I would have been doing magic with the numbers that I read. Two things. I think the first thing is that I want people to not to leave this place thinking that I have said since 2003 the CDF is unconstitutional. For many years, Karua didn't talk to me after I told him in 2003 during a workshop that CDF was unconstitutional as designed. Well, the court, many years later, the court ruled it unconstitutional that it was. And my argument is not that CDF is bad. And my argument is not to deny that CDF has done a lot of good things. It has. But I think sometimes those good things that CDF have done are standing in the way of transformation because they are blinding Parliament to the duty it has to ensure that all of the money raised from Kenyans is spent properly. So by being given 39 billion, next, Kenyans are losing a lot more. They are entitled to bigger benefits than they are being given under the current arrangements because this tokenism, and I think that's what Cornelius called it, this tokenism is blinding them to the bigger picture. I think that's the first thing I want to say. The second thing I want to say is that Kenya has a presidential system. And in a presidential system, Parliament and the executive are different and they have different responsibilities. And when you have fusion of authority or fusion of interest between Parliament and the President, what you're creating is something very close to a parliamentary system. Because in a parliamentary system, the government is located in Parliament. So what we are seeing now is an executive and a Parliament that have an aligned interest, so that Parliament is not performing the role it ought to perform in a presidential system, and it is behaving as if it is the party of the President in Parliament, which is then causing the problems that we are seeing with CDF. Thank you very much, and thank for all those of us, for all those who joined us online. We are very grateful. It would be very difficult to make this thing work if it wasn't for the participants who come to this forum. Thank you.
Thank you very much, Mr. Wachira Maina. I couldn't agree more. This is possible because of the attendees who make time to engage in such academic forums, which, as Mr. Ongoya noted, may not bear immediate fruit, but they surely count towards something. As he noted himself, an academic paper is the reason he ended up in this case in the long run. So we are very grateful that you joined us here today. And on to our very final parts, we'll have closing remarks from one of the conveners of the forum and who took part in organizing this particular session, Mr. Jared Gekombe. He is a lecturer at Kabarak University and also a doctoral candidate at the University of Pretoria. Mr. Gekombe, take it away.
Okay, thank you, Marion. Mine is to do a vote of thanks, but I think it has been done partly. So just to recognize all the panelists, thank you so much for creating time for the webinar. And also to appreciate you, Marion, as our resident moderator. Thank you so much for wonderful work you have done today. I also wish to recognize Mr. Gautam Bhatia, who attended our session and spoke. Mr. Walter Cheng was also present. Thank you so much. Also to recognize our Dean, Professor Mbani, our Associate Dean, Madam Wakuraya, they have been present, together with all the HODs who are also present and members of faculty. And also to recognize our students, the Canaanites, they were in large in numbers. Thank you so much. And also to all the attendees, members of the public, the lawyers, and I recognize one of our good friends, Mr. Atunga Atuti, actually joins us from Australia. He has been a very good fan of Avid readers, and I appreciate that for attending. So I look forward to, maybe mine is to challenge the panelists. I know there's a conversation elsewhere about this. If we can put our thoughts in, in a publication, a book, a journal, I know there is a conversation around that.
Hello, Mr. Gikonyo. Can you hear us? Mr. Gikonyo, can you hear us?
Yes.
Seems like Mr. Gikonyo can't hear us, but I think you get his message. We are very grateful as the Avid Readers Forum for your presence here. We are grateful to everyone who took part in organizing this. We are most grateful to Ms. Wanjiru Gikonyo, who was the brains behind this forum. Thank you very much, Ms. Wanjiru Gikonyo. We would absolutely not be here at this time today if it was not for your great partnership and initiative. I'd like to thank the people who took part in organizing this session. Nyaberi Sylvia, Mr. Gikonyo, Elisha Ongoya. Thank you very much to everyone who helped publicize the event in one way or the other. You commented on our social media posts. You posted about the event yourself. We are eternally grateful. We cannot thank you enough. Thank you very much. And we will, as Mr. Elisha has noted, we have more sessions coming up. This was just a tip of the iceberg. We have a whole iceberg to unpack. So be on the watch out. Something is coming, something is cooking, as Gen Z would say. Tuko jikoni. We are currently making something for you. Stay put. We'll be reaching out soon, and we hope you will join us in the same spirit. And of course, it will be very informative, just as this has been. We don't do anything that's not informative. Thank you very much to the Kabarak Law School administration for enabling us to do this. Thank you very much, Professor John Osogwambani and Ms. Rahab Wakura. Thank you very much for that, for your support. And now I'd like to invite one of our very own organizers, Madam Sylvia Nyaberi, to offer the closing prayer, after which you are all free to leave at your own pleasure. But leave knowing that we were eternally grateful for your presence. Madam Sylvia, take us to the Lord.
Okay, let us pray. Gracious and merciful Father in heaven, indeed we are thankful for your mercies and thank you for allowing us to have this discussion. We do pray that whatever we have discussed may be of benefit to us and may you be able to make the world a better place. May you bless all the participants and the panelists who have been able to join, and dear Father, may you protect them till our next webinar. It is my humble prayer in Jesus' name. Amen.
Amen, amen, and may it be so in the name of God. Thank you, everyone. Have a good evening, morning, or afternoon.
Thank you.
Bye.
Bye. Asante, thank you so much. That was awesome.
I will see you, see more of you. Yes.
Awesome.
Dudley, Ongoya, my co-panelists. Wachira. Oh, by the way, I should have told you that I read all these critiques you write of the Supreme Court. I'm religious about that.
So much. Bye. Good evening.
Webinar. Yeah.